Cynthia Miller, are you a sitting judge?
I am.
I'm sorry to say, and I have a duty now to report this to the state bar.
There's a pattern. There was a proceeding involving this judge was found guilty of covering up or attempting to cover up a crime.
Good morning, Judge.
I'm going to call this case, and then we need to have some discussions. This is the matter of the City of East Lansing versus, is it Simony?
Yes, that is correct.
Okay, thank you. Simony Cole Griffin Miller. This is a date and time set for an arraignment. So there is a person named Cynthia LaToya Miller present. And could you just identify yourself, please?
Good morning, Your Honor. Cynthia LaToya Miller on behalf of Simony Cole Griffin Miller, P55928.
Okay. And Cynthia Miller, are you a sitting judge?
I am.
Okay.
And Simony was, I was Simony's guardian until she turned 21. She's like my daughter, so I'm only here for this limited purpose. I was trying to see if they're good.
And that is, in my understanding, the law and the canons wholly improper. There are statutes at issue. I think you're a circuit court judge, and so the applicable statute is MCL 600.562 that says a circuit court judge shall not practice as an attorney in any court of the state. There's canon number 4H that prohibits the practice of law for judges. So I am not moving forward with you attempting to represent Simony Miller here today. We'll get to what Simony Miller, the charged defendant, can do, but I'm sorry to say, and I have a duty now to report this to the state bar. So Judge
Greenwald, my understanding was different. My understanding was that if it was an immediate family member, that there could be a limited representation. Like I said, I only came today to try to talk with the prosecutor and see if there could be.
I would find that to be wholly improper.
So I truly apologize.
Raise the appearance of impropriety, you using your office to speak with the prosecuting attorney. There's also an ethics opinion. Well, I'm just giving you the law. There's an ethics opinion, J2. It's from November 3rd. 1989, which says that allows a judge without compensation to provide legal advice and counseling to a member of a judge's family, but may not act as an advocate or negotiator or make appearances as counselor.
And Your Honor, with the respect in the world for you, and I understand your position, that was not my understanding. It was a mistake. My understanding was that I could speak with the prosecutor. I was not in any way, I never got to talk to the prosecutor or anyone. I tried to see if I could speak with the prosecutor just to resolve the matter short of us having to hire an attorney. We've just buried our mother, and it's been a very expensive period for my family. And I was just trying to simply get a resolution quickly to this matter, if at all possible. I did call your court building, and I let them know that I was trying to expedite if there was a way for me to talk to the prosecutor just to try to see if there could be some resolution. That was all I was trying to do for today. And so that was it. I apologize for the misunderstanding.
You've made that record, and that's all. And I'll also state for the record here that we're on Zoom here today. You're coming in, and it does say attorney Cynthia LaToya Miller. It does not say judge. I mean, nonetheless, anyone who would look you up on your P number would find that you were a judge. And
yes,
that is also consistent what you stated on the record with the chats that have been going back and forth with you asking to see the prosecutor. So for the reasons stated, like I cannot go forward with allowing you to make an appearance here.
Yes, ma'am.
And so I'm going to ask you to leave our Zoom. You can watch on YouTube, absolutely, but you're not a party. You're not representing Simony Miller. And then Ms. Simony Miller.
Your Honor,
sure.
Respectfully, may we ask for this to be reset so we can get an attorney to come in with Simony then?
I was just going to give her that option. We have all criminal defendants in Ingham County can be represented by the Public Defender's Office, and the Public Defender stands ready to represent you today for this first hearing arraignment. That does not mean you need to stay with the Public Defender's Office. You could hire an attorney after that, or I'm happy to adjourn the entire matter and you can retain counsel of your choice. Simony Miller, what would you like to do? So my question to you is, do you want to go forward with this arraignment today? You'd be represented by the public defender, and then you would have time thereafter to hire an attorney of your choice if you wanted, or if you qualify for the public defender's office, you could be represented by them. Or I would absolutely, if you ask for an adjournment of this arraignment, I would grant that request and we'd set this for another date.
Okay. And so there's no penalty for an adjournment?
No.
Your Honor?
No.
Okay, Your Honor. I would please like to reschedule an adjournment, please, Your Honor.
And we'll get a next date. I'm not inclined to give a lengthy adjournment. This is a driving while intoxicated allegation, and bond conditions could be appropriate. Well, I would like to get the arraignment taken care of as soon as possible. So we'll look for a date next week. That means that you have to act expeditiously to retain counsel.
Yes, Your Honor. Thank you, Your Honor.
You're welcome. So our arraignment will be adjourned to June 22nd
Yes,
at
Your
9
Honor.
a.m. And that'll be on Zoom, just like today, unless you wish to come in person. Is Zoom good for you?
Yes, Your Honor.
Okay, very good. So we're going to adjourn this matter. The court will expect counsel representing you and counsel to file an appearance in this matter before that arraignment. Simony Miller, any other questions for you?
No, Your Honor.
Now calling case number 18, docket number 377440, People of Michigan versus Michael DeGraffenried.
Good morning. May it please the court, Deborah Blair on behalf of the people, the Wayne County Prosecutor's Office, the appellate in this matter. This case really boils down to three issues that were raised by the defendant in his successive motion for relief from judgment. The first was a Brady claim regarding Tia Manning's police statements. And I think fundamentally the defendant in the trial court chooses to forget that defendant was present during the preliminary exam when Tia Manning in open court, her police statements were read on the record.
So let me ask you this, if I can just dive in. I think it's pretty clear from the record that there's some factual errors and that there's some legal errors. And I'm sure you and Mr. Buffman have talked, but the case before this one was the same judge, I believe.
Oh,
So I'm curious what you think we can do as a bench to make sure that these 6500s get handled with greater fidelity to the court rules. And to make sure that it appeared from the record that, for example, the trial transcripts either weren't made available to the trial court or were not reviewed by the trial court. So I guess that's my first question. Was it the former or the latter? Were the trial transcripts available? And then the second question is, what can we do as an appellate panel to kind of make sure these are being done right the first time?
well, I can't speak specifically as to whether Judge Green read the trial transcript. They certainly were available. I had them, defense counsel had them. If they were requested, I certainly would have printed out a copy. I was able to receive them from the Odyssey website. So I don't think that the accessibility was necessarily the problem here, but certainly
There's a pattern. I think what we're getting at here is there's a pattern. Is there any evidence of vindictiveness or anything that he wants to bring to this court's attention that we need to be aware of? Because this is frankly silly nonsense that's wasting a lot of people's time.
well, I certainly, as a prosecutor, felt like I was behind the eight ball the whole time this case was going on. Like, as if the burden was, again, on the people. Like, the defendant hadn't had a trial, a direct appeal, a motion for relief from judgment where he raised 12 issues, and now we're at a successive motion for relief from judgment. I still felt like the judge was putting the onus on the prosecutor to essentially reprove the case. And I just think that in her courtroom, it seems to be that is the pattern, in my opinion.
Just wanted to say that we've read the briefs and we've identified several legal and factual errors, but I know you were in the middle of discussing some.
Yeah, if you want to jump in on that.
So she set you up so perfectly.
Yeah, I feel like,
You're going to win, so, what more can you say?
right, I just
We're sort of at a loss as to what more we can do, because we recognize that this is unacceptable and difficult for a lot of people.
Well, yeah, I mean, not only us, not only you, not only defense counsel, but, it creates a false sense of optimism in these defendants who think they're going to get another shot at the apple when clearly, the law does not provide that type of relief. So it doesn't do anybody in the criminal justice system any good. And when we see, quote, repeat offenders, end quote, like this particular judge, we want to know, is there something that we can do to say, hey, either learn the law candidly, pay more attention, or is this vindictiveness on your part against the people?
yeah, and I think that definitely needs exploring.
I mean, we know, we are well aware of the background here. We're aware that there was a proceeding involving this particular judge, that she was found guilty of covering up or attempting to cover up a crime committed by her son. And if there was some reverberation from that, it would not surprise me. But I don't know if that's the case. But it certainly is starting to look to be that way.
And that,
Like, you're going to pay for this.
yeah, and that's how I felt during this case, because the target kept moving. That I was never, as a prosecutor, secure that these were the only issues that were going to be raised. As the case was adjourned multiple times, more and more issues were then added, changed, removed. It was a very difficult case for beginning to end, but unless the panel has any other questions, I would
Thank you.
rest on my brief.
Appreciate you bringing this to our attention.
Thank you.